and we're glad you're here today. Thank you.
Good morning. I appreciate the opportunity to be here to take a break from working on comments on the Clean Power Plan and to talk about some other things that are haunting the industry. So, as was mentioned, this is kind of what I would call a roundup session, or it's part of the potluck. These are just a few other things, other topics that are driving controls, not really just at coal plants, although that's going to be the primary focus of these rules generally, but also at gas plants, and then for several of them, and I'll try to point out when, it's really an industry as a whole, so other manufacturing as well. So just a quick overview. I'm going to touch on regional haze. We're finishing up the first planning period. There's a little asterisk on that, looking toward the second, which is supposed to come in 2018. There's a revised Ozone National Ambient Air Quality Standard, or NAAQS, coming out. And then also I'm going to briefly touch on enforcement and citizen suits, which are also a driver for plant decision making, either technology, resource planning, that type thing. And two areas there would be new source review and then opacity. And just to help me to understand my audience, how many lawyers do I have in the room? A few, okay. And then how many are environmental or plant environmental specialists, right? Okay. And then other folks, technology or scientists, engineers, that kind of group. Okay, so some of these things I may hit on if you don't, if it's not clear what I'm talking about, we can follow up afterwards. I am going to have to move pretty quick. Each one of these topics could be a seminar, and our seminars in and of themselves, I have 30 minutes, and so it's going to be kind of fast and furious. But again, I'm available afterwards if anybody has questions, and then hopefully I'll save a few minutes for questions anyway. So my overview, my objective is really just to give you a quick overview on these. So the first topic is regional haze, and regional haze is actually a program to control visibility impairing pollutants. And visibility is the idea of haze, just like what you would think. It's not a health-based standard. It is what has been called the EPA's stealth tool against coal plants. It's not what you would normally think of to drive controls, but in fact it actually has done that. This is not just an electric generating unit, or EGU, I'll use that term several times, that acronym, EGU issue. This actually is any source that impairs visibility. You may be subject to regional haze requirements depending on the timing and the level of impact that you have on areas, your areas, Class 1 areas. So what is regional haze? Okay, the Clean Air Act, Section 169A, directs EPA to assure reasonable progress toward meeting the national goal of prevention of any future or remedying any existing impairment of visibility in mandatory Class 1 federal areas, essentially from man-made air pollution. EPA has done regulations on this. I'll do a quick overview of kind of the timeline of this program, but the idea is that you're to get back to background visibility at these Class 1 areas. Class 1 areas, this is a quick map of them. Primarily they're in the western part of the country, but there are some scattered throughout the rest of the country. In our particular area, which I'm in Arkansas, and Entergy service territory in its southern fleet is Texas, Louisiana, Mississippi, and Arkansas. We do have, it does drive controls potentially in the Arkansas plants as well as Louisiana plants. So EPA set a 60-year period to reach compliance back to background. So what we're looking at is a program that is on a time frame to get there by 2064. And so there's two planning periods under regional haze. The first guidelines came down in 1999. They were turned back by a court. EPA revised them and issued the final what's called BART guidelines. I'll talk about BART in just a second, in 2005. And then there were some subsequent rulemakings about things that are alternatives to BART. BART is the best available retrofit technology. Essentially it's the program that would be, if you have a source that impacts visibility and you're subject to the BART requirements, which would mean you, one, impact visibility, and two, you are within the the right age of the facility, which would be, it was built between 1962 and 1977, you're subject to BART. That's what the first planning period is really focused on, and so there's these other rulemakings. You can see CARE equals BART, later Casper equals BART. That was all about finding reductions or improvement in visibility that was equal to or greater than BART. The regulations allow for what's called BART alternatives, so you can have BART on the sources, or a state can come up with alternatives, and there's a couple that were given a nod in the Act itself regarding trading programs, particularly for states out west. But then EPA's created these alternatives on these transport rules that they could also be better than BART. The Casper equals BART rule is subject to challenge right now, so we'll see where it ends up. The basic idea is that the states had to and to submit their state implementation plans for the first planning period in 2007, and then they had to submit another plan for the second planning period in 2018, which is the second planning period is reasonable progress, and that's it's beyond BART. And so you would be looking at other sources that impair visibility, and you don't have the same limitation on the age of the facility. So it's a phased-in program. We did hear last week at the Clean Air Science Advisory Committee, which is associated with EPA, that EPA is looking at actually moving that 2018 SIP deadline out to maybe 2021 to try to better coordinate with the air transport rules and presumably the ozone standards. That'll be my next topic, et cetera. It's not clear whether that would mean the second planning period still ends in 2028 or whether it would be pushed on out. The planning periods, as you can probably tell, are about 10 years long each. And then in every 5 years, the states are supposed to submit progress reports. Okay, so I've talked about BART, and I won't go through all of the slides, but essentially BART would impose emission limitations on NOx, SO2, and PM for sources that are subject. And it is implemented through the state implementation or SIP program that a state puts together, and then the EPA has to approve. Now that, I should say, it's not actually implemented that way. It does get implemented that way, but in regional haze, we have seen a whole lot of federal implementation plans, and many times where EPA would come in, the state will do a SIP, and then EPA will come in and say, that's not good enough, we want you to do more. And so we also have quite a few FIPS, or federal implementations plans, in this program. So reasonable progress, which is really what we're looking at in the next planning period, which is, again, if you don't have BART sources, you might have other sources that are going to be subject. For example, we have a unit in Arkansas called White Bluff. It is a big coal plant, uncontrolled. Generally, it has ESPs, but that's about it. It'll soon have ACI as well for MATS. But it is a BART facility. Its sister plant, which is the same size, they're over 1,600 megawatts each, is what we call a reasonable progress facility. And that would mean EPA and the state will be looking to that facility to reduce its emissions so as to stay on what's called the glide path. Each state has one, and that's where you started when the program started in 2004. Out to 2064, and you have this rate of decrease that the state is supposed to stay below. And then the reasonable progress 5-year reports are to show EPA that the state is actually meeting those with looking at actual emissions and actual impact levels. Recent developments in BART, again, I mentioned Casper equals BART. It is under challenge. Also, we've had two relatively recent cases out of the 10th and 8th circuits about this, and both of them gave a real strong nod to EPA and their deference. The prior cases about BART and regional haze had really emphasized the state's role in the program, but these cases move away from this somewhat and really deferred to EPA in terms of their conclusions, and particularly what they would be able to require and what regs that the state has to adhere to, and it really decreases the state's role and discretion, which is unfortunate because given that this isn't a health-based standard, and it is a visibility-based standard, you would think the states would have a little more say in what they wanted to do in light of the cost of these type controls. For example, for our White Bluff facility, we're looking at about a $1.2 billion installation for BART. So independence for regional progress at some point could have a similar type obligation. So that's it for regional haze. Again, if anybody has any questions, I'll be happy to do them at the end. Then we have ozone NAAQS. That's the next thing I want to touch on. I think most people know what ozone is, but I'll just cover it real quickly. Ozone, ground level ozone that is formed by the interaction between sunlight and volatile organic compounds and NOx. That's why they're called NOx, ozone precursors, I'm sorry. And so it is a NAAQS, which is a National Ambient Air Quality Standard. I think most of y'all probably know what that is, but just in case, it's a national standard that EPA sets, and then requires the states to meet it. And so an area will either be in attainment or in non-attainment with the NAAQS, and it's up to the state to develop a plan, a SIP, to how to come into attainment if they're out of attainment, or to maintain their status if they are in attainment. So for the ozone standard has a long history, and so it started, the first standard was in 1971 for total photochemical oxidants. I don't really know what that is. I'm sure some of the engineers do, but I'm the lawyer, so go figure. I was, young, not that young back then, so I wasn't paying attention to that. But 1979, we got the first actual ozone standard. It was a 1-hour standard. And then in 1997, we got the first 8-hour standard. And the current NAAQS, which came down in 2008, is an 8-hour standard, and it's 75 parts per billion, both the primary and the secondary standards. But the secondary standards have been remanded to EPA by a court. After the one other thing. Ozone is not just an EGU issue. This is all industrial facilities can have ozone issues, or NOx. If they have NOx, VOCs, or PM emissions, they may have some issue with ozone. So, I'm sorry, I'm getting a little choked up. Thank you. I've actually got, there you go, thank you. Nothing like getting a stick in your throat right when you're giving a presentation. So after the 2008 ozone standard came down, there was quite a few suits that followed, and one of them was because that NAAQS have a 5-year review process, and so every 5 years the Clean Air Science Advisory Committee is to make recommendations to EPA about what to do about the NAAQS, and so ozone, for whatever reason, was not being reviewed on that 5-year schedule, and so there were suits to force that type of review. And so after the 2008 standard came down, and then they have the area designations about whether you're in attainment or not, there were also suits about the designations. Some states thought they were the erroneous designations, NGOs, non-governmental organizations, and other citizens groups felt like the designations weren't stringent enough, et cetera. Ozone is unique in regards to attainment and non-attainment designations insofar as the other NAAQS, you're either in attainment or you're not. But for NAAQS, you have, there's levels of compliance, and so you can have marginal, moderate, serious, severe, or extreme. And this is a map showing the attainment with the 2008 standard. And unfortunately, I'm not sure about which of the 3-year periods this is based on. I think it would probably be 2010, 2011, and 2012, given the date of the map. This comes off EPA's website. But this will show you generally where the country is for the current NAAQS. So as I mentioned, there's a review cycle every 5 years, and the EPA has been working on a revised NAAQS for quite a while. Back in 2010, the NAAQS was proposed to be revised downward, and that was unusual because with the standard coming out in 2008, Lisa Jackson right after that came out and said, you know, we're going to go on and reconsider this by 2010, which would have only been 2 years later, which is midway in the review cycle, which was somewhat unusual, and it was a concern, especially for states, because they were just starting to work on implementation of the 2008 standard, and here a new standard could come right back out again. There was some question about whether states would even try to comply. That standard, that revision moved forward, and it went to the White House in June of 2011 for a final rule, but about 3 months later, the president pulled it back. And so they then got back on what would be considered a normal review cycle. But of course, there was a suit about it, And the suit now orders, actually there's many suits that followed thereafter, but we have court-ordered deadlines for the review for December 1st, 2014. That's next month, and then a final by October 1st. And so interestingly enough, EPA has said, just like they did on the 2011 pullback attempt, there was that they'll be looking at a range of 60 to 70 parts per billion. And so this is really the crux of what I want to talk about in terms of ozone, because the current standard is 75. You saw what the non-attainment looked like, but what does the non-attainment potentially look like if it goes to something else? Well, okay, so this is one map you can look at for this, which will show you that these are the monitors for ozone. And so if you can see by the legend down at the side, if the non-attainment, if the NAAQS is reduced to 70, then you would capture all of the orange and the red monitored areas would be in non-attainment. If it goes to 65, you can add the yellow. If it goes below 65, you add most of the light blue and some of the navy or purple, whatever your eyesight tells you that color is. My eyesight doesn't tell me as much as it used to, I can tell you. And so this would not be the only counties in non-attainment. Non-attainment is normally done on the metropolitan statistical area of the monitored county. So if you were in, for example, in our area, there is a non-attainment area near Memphis, Tennessee, and all 3 counties get pulled into that. One's in Arkansas, one's in Mississippi, and one's in Tennessee, because that's the metropolitan statistical area for that particular area. So the concern in terms of whether you go into non-attainment is because once you go into non-attainment, you have several things follow. One is the state has to meet it, and if they can't meet it on the deadline, then their highway funds are at risk. Also, in terms of they have to do state implementation plans to implement it and do direct measures on the sources to meet the standard. And so whereas the NAAQS doesn't actually reach the facilities, the SIP requirements do. And so they have to come up with the SIPs, and then the sources have to comply. And then there's heightened permitting. And so when you're in a non-attainment area, 2 things occur. One is you're subject to the lowest achievable emission rate, which is just like it sounds, the lowest achievable emission rate without taking into consideration costs. If it is technologically feasible, you are to meet it. Now, there's some caveats to that, but generally, that's the requirement. That differs from the PSD, or Prevention of Significant Deterioration program, which is for the attainment areas, and that relevant technological standard is called BACT, Best Available Control Technology, where you can take some costs into account. But you have layer, and then the second thing you have to do is you have to get offsets. So if you have a new facility or you have a modification to an existing facility and you're going to increase emissions of the ozone precursors, you have to get offsets either from within that non-attainment area or from a related non-attainment area that is impacted by your attainment area sources, and it has to be an area that has a lesser it has a more severe attainment status. So you have a real limited ability to either put in new sources or modify sources when you're in a non-attainment area. So it's been raising some concerns around the country. You may have seen this map. This is from the National Association of Manufacturers. Their projections of what non-attainment areas would look like if the standard goes to 60, which is is a rumor that we're hearing that 60 is the likely number, although I hope that's not the case, because most of the country goes into non-attainment, and the ability to site plants, including the gas plants, that will be so crucial to the implementation of the Clean Power Plan will be very difficult. But again, this isn't just an EGU issue. This is for any manufacturing facility. You're going to have this issue. Now, I will make one note that this is NAM's extrapolation of the existing data. We don't know that this is exactly how the non-attainment areas would look, but based on current data, and this is actually based on 2011 to 2013, 3-year average, this is what it would look like. Okay, so what's the timeline? Okay, if the new revised ozone proposal comes out on December 1st as ordered by the court, then you would have an effective date. You would have a final come out in October. That's also court ordered, like I mentioned earlier. Effective date would be a little bit later. We're looking at about December of 15. You have area designations would be finalized 2 years later. SIPs are due 1 year thereafter. And so then what does it mean? Well, if you're marginal, you have 2 years to come back into attainment, and then it just tiers out depending on the severity of your non-attainment. And by the way, depending on the severity of your non-attainment, the requirements and the measures that are required for you to come into attainment are, more stringent. You get longer to get there, but you have more obligations. So for example, your offsets may not just be 1-to-1, you may have to get a 3-to-1 offset to get a new or a modified source in place. Okay, so third big topic is about enforcement and citizen suits. I'm going to touch on new source review and opacity, and both of these I'm going to have to really move through pretty quickly, but essentially what this is, it's not a regulation. New source review is a regulation. Opacity obligations are regulatory based, but this is not just like a regulatory program like one would think of like regional Haze or Ozone or the Clean Power Plan. This is enforcement suits and citizen suits. Under the Clean Air Act, you have civil enforcement under Section 113, and then you have citizen suits under Section 304. Both you can get what would be called penalties and injunctive relief. And it can go somewhat beyond that. And so what we're looking at in terms of federal enforcement or state enforcement, if you're under the 113, would be you have penalties, and it's $37,500 per day of violation. Now that's a maximum. They usually ask for that at the front end, but then the cases usually do not go to that level in terms of penalties, but it is one of the risks that you run. So there's some things you consider when you're looking at penalties, and then you also have injunctive relief, which again is a prospective remedy looking forward, and that could be anything like you can't have any more violations, you have to reduce your emissions, you have to close down your facility, you have to implement controls, etc. It's the plaintiff's burden to show that they're entitled to injunctive relief. And so, the actual new source review program, just another quick question. How many of y'all are familiar with new source review? Okay, so we got a pretty good group. That's good, because it really is a seminar in and of itself, and so I can't go into it too deep, but essentially it's a stationary source pre-construction permitting program for new and modified sources. And it is to achieve the NAAQS. As I mentioned, you've got the PSD program, which is for areas that are in attainment, and then you have the non-attainment new source review program for those that are in non-attainment. And then for the smaller or non-major sources, you have what's called minor new source review. It essentially is that, and I'm going to focus on major modifications at existing facilities because that tends to be where the majority of the enforcement cases are. And so if you have a major modification, again, at a major source, then that is considered to be a physical change or a change in the method of operation that results in a significant increase in emissions of any regulated NSR pollutant and a significant net increase in the emissions of that pollutant. Okay. Practically every word in that definition has been litigated and has a whole suite of case law that goes with it. So it's one of those, it's a very complicated area. It's got a lot of gray to it. And of course, what EPA thinks versus what citizen suits would be proposing versus what industry and sources believe, everybody has a different opinion of what things mean. So it's been quite contentious over the years. The hot topics in the NSR arena are really about whether NSR obligations are, do they continue or are they a one-in-time violation? And so the question is under the Clean Air Act, you have two programs. You have the pre-construction permitting program and you have the Title V operating program. Again, this is for major sources. And so, which don't get caught up too much with the word major because it actually has different definitions depending on those two programs. But essentially the bigger sources, you're usually required to get either two types of permits or one permit that is combined depending on your state. And so the question is new source review, is it a construction obligation, or is it an operating obligation, or is it both? EPA and the citizens groups have asserted that it is an ongoing obligation. It is both construction and an operating obligation. The circuits courts have been split on this issue. It appears that the circuits that would say that it is not a continuing obligation are winning, or there are more circuits now that are saying that these obligations are merely a construction obligations and they don't flow on into current day in terms of your operations, and that matters because of the statute of limitations. And if it is not a continuing violation, then there is a 5-year federal statute of limitations that would apply not only to the citizens, but also to the government in terms of enforcement actions. There's lots of information about this if you're interested in this that I can point you to, but again, it is a split in the circuits, so that would mean there's a lot of law on both sides of it. Some of the other questions that would then flow from that are, is equitable relief available? I mean, can you still get an injunction if you can't get penalties because of the statute of limitations? Has forestalled the penalty part of the case? Is the failure to install back a separate violation? I mean, is back just a construction obligation, or is it something just for, is it part of your operating requirement? What extent can EPA second guess your pre-project projection? So essentially what you do as a pre-construction permitting obligation, you have to go in, you have to do your analysis of what your baseline emissions are to what your projected emissions would be after your modification. And that's really where EPA and the citizens have done a lot of work, and they are looking at what you're proposing before you go in. Because there's a question about if you even have to go in and talk to the agency, whether you even have to get a permit based upon your baseline to projected analysis. And that's where these suits really start getting complicated as they try to pull back and dig into all of the work you did. Some recent cases have determined that EPA's ability to second guess the company's projections is somewhat limited. Not to say you don't need to keep doing it, and in fact you need to do it right, and if you're not sure about what steps to take, I urge you to look at the DTE case, and it will kind of walk you through. If there's cases, we have projects where we're like, we know it's not going to increase emissions. It's on something on a turbine, and it has nothing to do with the boiler, which is the emission source, but you still have to go through the motions. That's one of the things that have come out of the recent cases. Recent cases have been about whether former owners can be liable for past NSR violations. Looks like the answer to that's going to be no, but again, there's still a split in the circuits, and until the Supreme Court rules on that, if they ever will, then it might be somewhat up to question. And then also we've had some recent cases about the routine maintenance, repair, and replacement exemption to new source review. Essentially, if you're going into your plant and you're doing RMMR, it is not considered to be a modification. So it's a frequently used exemption to NSR, and there's been quite a bit of attacks on that. Okay, so last topic, citizen suits about opacity. Perfect. Okay, so opacity, thank you. Opacity refers to the amount of light obscured by particles in the air, and essentially it's an indicator potentially of the performance of your particulate control system. Most of you guys are engineers and scientists, so that's about as much as I'll say about the science of it. The opacity standards, can be required under the new source performance standards, could be under your state plan, could be part of your PSD NSR permit when you first constructed the facility, or due to a modification. And then also you might have state-only requirements, and most of these would be all contained in your Title V permit. The form of these standards is really complicated. It's not like, a pounds per million BTUs limitation or a pounds per hour, for example. They tend to be these combined type combined type limits where you've got, you can have so much opacity at a certain level for so long, and then you've got some exemptions. So if any of y'all have opacity limits in your permits, you'll understand what I'm saying. But what it means is it makes enforcement somewhat complicated. You also have continuous opacity monitors, and so we report any deviation from the opacity limitations, or you're supposed to. And so each one of those opacity deviations can hold the potential for an enforcement suit or for a citizen suit. So why does it matter? Well, because in the last 20 years, there's been over 35 notices of intent to sue on Opacity for coal plants. And this is one of those things, it's a trend, it's moving from east to west across the country. It's kind of I would say it's kind of a citizen suit topic du jour, but it's really not du jour, it's really over the last 20 years, but it has been growing, it's been gaining ground in recent years because it's a situation where you have to report the violation, so there's credible evidence about what the deviation is in the record at your state agency. That's all subject to Freedom of Information Act requests. The NGOs get that information, and then they put together these cases against you. And sometimes they have thousands of alleged violations. I think that the one case had 89,000 violations alleged. And what you've got is these little spikes in opacity. You've got these little exceedances, and then you report it, and you do it over the, say a 5-year period, and you really can have a big case on your hand. So what are they seeking? I realize this slide actually is really about almost my entire presentation. What are plaintiffs seeking by use of these programs? They're trying to increase the cost of coal-fired generation. They're trying to force technology controls. They want to influence your resource planning decisions. They want you to think about how much is it going to cost to really run this plant and whether it's worth it, and want you to just shut it down now. Also in the NSR and the opacity cases in particular, they're also looking for publicity and fundraising. They're suing you on your plant, that raises money in your area or in your state or just nationally. And then they also get attorney's fees under the citizen suit provisions. So tips and takeaways, this is also somewhat apply to both NSR and opacity. Don't exceed any of your requirements if you can help it. I know that's easier said than done, particularly for opacity. But strictly adhere. Don't make a case for people, especially on things that you have to do reporting, because you're literally just creating the record for enforcement or a citizen suit against you. Optimize performance and compliance, and you should advertise that. Be a good corporate citizen and talk about that. Talk about it with your state. Cultivate a good relationship with your state. And the reason that matters is they can be your ally. They can permit past violations for the future. You can get permit amendments. They can do diligent prosecution, which is if they are pursuing a violation, that can forestall a citizen suit. Also, they can be, in some of the cases that I've been involved in, the state may actually be some of your witnesses. And so you want to have a good relationship with your state. Also, when you get your notice of intent, which a notice of intent to sue is a requirement under the Clean Air Act and the citizen suit provision that someone intending to sue has to give a 60-day notice before they actually file the suit. And so those are called NOIs, and you should look at them very carefully. And sometimes they don't have adequate documentation. Other times they just have the exceedances wrong. So you really should take the time to carefully review those, even if it's the 89,000 violations case. And also there can be defenses under your state implementation plan, for example, for malfunction, startup, and shutdown provisions. And that area may have somewhat of a lesser opportunity to be a defense as we move forward into this new period with EPA limiting the defenses that are available under startup, shutdown, maintenance. And then also I would just say, just be prepared for the long haul. And the reason I say that is because usually the time between a notice of intent to sue and the actual complaint is about 6 months. They put these NOIs out there. Sometimes it gets EPA moving, sometimes it gets your state moving, so they don't end up ever having to file a suit. Other times they will go on and file a suit. Again, that's about a 6-month period. And then the trials and the litigation actually occurs. It usually takes anywhere from 1 to 5 years, and they don't like to settle early. They usually wait until after there's been discovery and after motions for summary judgment. So you're going to be in for the long haul, and it's going to be expensive. So try to avoid it if you can. And that is all I had. I don't know that I have time for questions, but thank you.
Yes, we have time for a question or two. Yes, sir. The microphone.
Thank you, Kelly. Nice job. One of my questions is, for the states who have to comply to both regional Haze and CSAPR now that CSAPR's back on the table, can there be a conflict between the two? And if there is, will that prevent the state or cause the state to delay its role in CSAPR?
I would say I'm sorry, did you say that, are they interrelated between the two?
Basically, if there's, like for instance, a lot of the states under regional haze were forced to take FIPS. And I'm not sure how that's going to play out. Are they going to accept that? Is it settled? Are they going to execute those FIPS? Or are they going to fight back? And then when they are fighting for that, is that going to delay their SIP for Casper and cause confusion between the two?
I think the latter is a definite yes, confusion. But I think it really depends on the state, and it depends on the sources within your state, right? And kind of what the timeline is. So there are the transport rules equal BART rulemakings, right? The Casper equals BART, and again, it's under challenge, but right now it's going to stand. And so if your state has, and in fact it stood even after Casper got vacated, EPA's position was that the Casper equal BART rule was still valid, because it still provided, if you were going to comply with Casper, it provided more benefits, more visibility reductions than BART. And so I would say that there's going to be more, now that Casper's been upheld, and it's going to be a couple years to get the challenges, I think more states are going to look to go to Casper equals BART and minimize their obligations under the regional haze FIPS. That doesn't, though, meet their next planning period obligations, which again, right now is due in 2018, but EPA is looking at either through a rule or guidance moving that out to 2021. Did that
Okay, so you're saying it's going to stand, Casper equals BART will stand, at least for this phase, you're saying that the Casper equals BART will likely stand in most states as acceptable.
Yes, I believe it will. And I think other states, like for example, some of our states didn't pick up Casper equal BART. Now that's only available in the places where you're subject to Casper and only for whichever program you're in, right? So if you're in the annual program, then Casper would equal BART for SO2 and NOx. But in the seasonal programs, it would only be for NOx. And so you still have to have BART SIPs for your SO2 and your PM. So it's, it really depends on the state and where you are under each of the programs.
Time for one more question. Anyone? All right, great. Thank you so much.